In a divorce case, there's generally four major areas that are looked at if they're minor children. The first major area is custody, and in Massachusetts there are two types of custody. The first type of custody is legal custody, and if you're married there's a presumption that both parents are going to have legal custody. Legal custody means making major decisions regarding the child's well-being. That can be anywhere from decisions about school or religion or health decisions, but major decisions rather than day-to-day decisions. The second part of custody is the physical custody, or who's going to be the primary caretaker. What the courts look at is what's in the child's best interest, and generally they're going to continue with the parent that's been the primary caretaker throughout the child's life. There can be joint physical custody, but generally one parent or the other is going to have sole physical custody with a parenting or visitation arrangement. There's a lot of flexibility if you reach an agreement about what type of visitation schedule would be allowed. You can talk about every other weekend and one night during the week, or there could be other circumstances where just liberal open-ended or reasonable see and take, and I can explain that in more detail. So custody is the first major issue that the courts look at. Intertwined with custody is the next issue, which is child support. And child support is one of the few areas in a divorce that there is a formula or a guideline that's supposed to be followed. So what you do is you plug in the numbers of quote, the custodial parent or the parent that the child or children is living with, what their gross income is before taxes or things are taken out. You look at how many children there are, any cost for daycare or childcare costs, any out-of-pocket health insurance, dental insurance, and in other medical insurance, and what that out-of-pocket cost is, and then you do the same thing with the non-custodial parent. The formula then looks at what the weekly support order would be, and in general, in most cases with both parents, income is straightforward and no self-employment and not a lot of issues with bonuses or cash businesses, things like that. It's generally one of the fewer areas in a divorce where you are able to get a number, and if you came in, I'd be able to give a child support number probably within 5 minutes of getting most of the materials. So there's child custody and then child support. The third issue is alimony or spousal support, and that's all less clear. There are some calculators that you can look at, and I have some programs that can tell you what might be potential spousal support or alimony, but it really fluctuates from court to court and from judge to judge, and there's not really any uniformity with that. With spousal support, there can be an issue saying that there's past, present, and future. You can do a waiver of past and present and just say we're going to keep future. We don't know what's going to happen in the future, but we're going to keep future open, or we're going to see after the youngest child is an adult, then we're going to figure that aspect of it out. There are a lot of different things that are looked at, but even if the parties don't want to have alimony or spousal support, it is a big issue that the courts look at. And again, that's looked at when you're looking at the child support factors as well. And then the fourth major issue that the courts look at is division of marital property. Massachusetts is not one of those automatic 50-50 states. It's something called an equitable distribution state. And much of what is looked at is based on these factors that I'd go through with you. But what's looked at in terms of division is a joint marital property, and generally for midterm to long-term marriages, most of the property is probably going to be considered marital property. And then how is that to be divided? And it can be anywhere from looking at a house or the equity in the house to cars, personal property, pensions, retirement accounts. Also includes credit card debts and loans and things of that nature. Again, there's not a fixed way to do this. A lot of times in a long-term marriage, the parties will start out in a 50-50 but can argue the different factors. This is one that is, in many circumstances, one of the more complicated ones for the courts to look at and for people to deal with. But we'll go over particularly issues with houses. In addition, when there are retirement accounts, there are generally penalties if you transfer retirement accounts if you're not getting a divorce. But when you do get a divorce, there's something called a qualified domestic relation order, or quadro, which can be presented to the court, and the court would basically make an order allowing a portion of a retirement account to be put in the other party's name. So these are the four major areas that the courts look at, and just a thumbnail sketch of those. There are other issues anywhere from health insurance to maintain that for the ex-spouse and for the minor children, to who pays the uninsured medical and dental for each party, to who pays the uninsured medical and dental for the children, if there's going to be a requirement for life insurance, for the year that filing the divorce, are the parties going to be filing joint or separate tax accounts? For the children, are they going to alternate the child for tax dependency exemptions? What's going to happen with future wills and inheritances, and a lot of other issues. But those are the four major issues, and again, that's child custody, child support, alimony or spousal support, and lastly, division of marital property. And that's just a thumbnail sketch regarding those pieces. Regarding filing a complaint for divorce, there's not a lot of information that's needed in order to file. You do need your marriage certificate. Like, you do a motion to file late in order to put the marriage certificate in at a later date. But most of the information to file is pretty basic information, meaning the spouse's full names, dates of birth, date of the marriage, when the marriage broke down, and things of that nature. And what you're looking to get from, with the divorce, are you looking to get custody, are you looking to get transfer of the home, things of that nature. But basically what happens is I would fill out the paperwork for the divorce, file that with the court would docket it, assign it to a judge, and that judge would likely be the judge that would have the case throughout the divorce proceedings. And after that's docketed, the court would send me something back called a domestic relations summons. I would serve that upon the other spouse, and you would give me that information. I have a constable or sheriff serve that person. And then that person would have 20 days to answer the complaint for divorce. We could also mark it up for something called temporary motions. And temporary motions mean that getting a divorce can take anywhere from months to even years, and they put things in place while the divorce is pending. So you can ask for exclusive use and occupancy of the home on a temporary basis. You can ask that the other spouse pay child support on a temporary basis, pay alimony on a temporary basis, pay for bills on a temporary basis, a lot of different things to maintain health insurance and so forth. We'll be going through that with you. And as we go along, before we go to the first court date, we would need to get financial information, which is called a financial statement that I'd work with you as well. The next stage, after filing a complaint for the divorce and getting the answer in the temporary motion stage, is usually a case management conference and then a pretrial conference date. The pretrial conference date is really the more important aspect of it. You're required to have a four-way meeting with the attorney from the other side and the spouse. So it would be four people sitting down and trying to go over what the issues are and what we can agree on and what we can't agree on. If we can agree on everything, then we can go into court with something called an uncontested agreement. If we can't reach an agreement, then what would happen is we would go in front of the judge and we'd just do a memorandum for the judge, and we make these arguments to the judge about what you're looking for should happen. The other side makes an argument about why they're looking for should happen. And the judge will say, I'm not hearing this at trial, I'm not making any decisions, and I can change my mind and I can get other evidence and so forth. But basically saying what I read in your memorandum and what I'm hearing from the lawyers, this is what I would likely do. And in most cases, that's going to give you a real good idea of how you want to settle the case, because that judge is likely to be the same judge that's going to hear it at trial, and it's going to be very expensive to do a lot of discovery and to prepare for trial. However, if you're not able to resolve it at the pretrial conference stage, then what you end up doing is setting it for trial stage, and that has a whole nother avenue in terms of preparing and getting materials and so forth. 90-some-odd% of cases end up resolving short of getting set for trial, and probably 99% of cases resolve before actually completing a full-blown trial, if nothing else because of the economics behind it.